Morning. It is April 17th, Tenant Judiciary. We are revisiting H21, which was dare I say, pretty straightforward. We have ledge counsel with us just to go over some questions we had a few weeks ago.
Hi, good morning. Eric Fitzpatrick with the Office of Legislative Counsel. As the chair said, here to talk with the committee a little bit about H21, which is an act relating to service of written possession. Committee may recall that this had to do with the subject of service of a particular kind of court process. Right now, sheriffs and deputy sheriffs have statewide jurisdiction. The serve process, that means essentially when you say process, you're referring to some order issued by the court or some court document. Could be a subpoena, could be a complaint, could be a summons, anything of that nature. This particular type of process that we're talking about in H21 has to do with a particular kind of proceeding, an ejectment proceeding. A writ of protection comes about in an ejectment proceeding. So someone has made a claim that someone else is occupying their property unlawfully. That could be a landlord-tenant situation. It could be a situation between adjoining property owners where one property owner says, you built your tool shed that's actually over halfway on my property in the back, you would bring an ejectment proceeding. So it's any kind of claim by one property owner that their property is being unlawfully occupied by somebody else. That's an ejectment proceeding. And this proposal that you're looking at in H21 has to do with a writ that's issued in an ejectment proceeding called a writ of possession. So somebody brings the ejectment proceeding, the court agrees with the person, says you're right, that person is occupying your property unlawfully. The court can issue a writ of possession that's directed to the sheriff, the server that tells the person to turn that property over to the rightful owner, the lawful owner. And because of a historical accident that no one has ever really been able to track down why, for some reason, because generally speaking, sheriffs have statewide jurisdiction to serve court writs of possession. Court process generally. But in the particular statute for writs of possession, they can only be served, this is lines 11 and 12 that are struck through, have to be served by the sheriff of the county in which the property is located. So it's a specific limitation on who can serve a writ of possession. And the proposal that you see in front of you and that passed the House is to permit any sheriff to serve the writ of possession. That would be consistent with the way court process is served. Generally served statewide. Courts have, sheriffs have statewide jurisdiction to serve, and that's the proposal here to allow that same statewide authority with respect to writs of possession that there already is for other court process. The question that came up, you may recall, was what about deputy sheriffs? And that the question was, well, can deputy sheriffs also serve the writ? And the statutes were a little bit ambiguous about that, but I think Senator Norris and myself spoke with Sheriff Anderson, I believe, who indicated that they interpreted the statute to permit deputies to serve as well. So I think that the conclusion was they were reading it that way, and there probably wasn't any need to make a statutory change for that. I'm for putting words in Senator Norris's mouth, but that's kind of what I recall.
No, and part of my other concern with it, if I might, is this is the service of the writ. Okay, and this stems further into, does this also cover the execution of the writ? Was my question. I don't think I got a definitive answer on that. Two different processes here.
Right. The serving of the original writ, and then if the person refuses to leave, then they have to, the execution.
Writ, 14 days, not sooner than 14 days.
Right. And I think the reading on that was that it did cover execution, but again, we had sort of a
ambiguous.
Right.
They were comfortable with it. Their attorney was comfortable with what we were told.
Right. Exactly.
They're the ones that executing it.
Right. Yep, that's exactly what I recall as well. The language didn't seem entirely clear, but they seemed to say that they read it that way and they were comfortable with it, and so that they permitted execution as well as serving the writ.
Do we have any other we didn't make any, I don't even think we made any changes
No,
to this.
correct.
Committee, what do we feel about this? Are there any lingering questions or thoughts?
It's only bonds. Just the ambiguities that was.
Yeah.
I mean, it feels very straightforward to me. I'm like, it's almost a technical question.
That's what I'm thinking too. I think to your concern, Senator Norris, I think it sounds like the ambiguity is relatively cleared up. Unless you think there might be any changes we can make that makes it a bit more clear so that people aren't uncertain in the field.
Well, I think when I was speaking with Eric, we just wanted to make sure that things were clear, and that's why I reached out to Sheriff Anderson. And because we were of the same mindset that maybe it's not quite as clear as it should be here, and then along came the question of what you just answered, execution of the writ is also covered on this particular, not just the service, but the execution of the writ itself. Right. Deputy sheriffs and sheriffs can execute the writ. And this covers that. It doesn't mention it, but it covers.
Right, elsewhere included in that, at least arguably enough. And then what they were seeing was, yeah, they read it the same way.
That's fine by me. If they're comfortable with that, I'm sure you want to tell the sheriff what.
Well, in that case, if we're good to go, I would entertain a motion to vote this out favorably.
I'll move that.
Any further discussion? Senator Meadows.
I love to try.
No rush. No.
Oh,
Do you have
they
a,
are in the printer. So let me go grab those real quick. Oh, sorry.
So if you do vote it out as is, so there's no amendment, right? You're just concurring in the House bill. So I understood yesterday, I thought there might have been some confusion with the Senate Clerk's office about whether or not there had been an amendment made, but in this case, to a different bill.
is that S9?
Yes.
I think it was that's not right.
Melissa came straight mail it on this morning.
Oh, okay.
We're good to go.
All right, great.
All right. Well, so were there no changes to that one too? Was that S9 another one?
That was concurred.
Concurrence. All right.
So there wasn't the amendment from this body or this committee.
Right.
Before that stuff.
Yeah. We should be mistaken in this case, I think. Thanks. I think there's some sheet of paper. I want to remember that district is a refresh my own recollection. Even though there's no amendment, that there might be some sheet of paper that the reporter, whoever's going to report this.
The original bill.
Yeah, the original bill, and then a sheet that says they concur, 5-0, whatever the vote is, and signed by whoever's going to report it on the floor.
She had that. She had one, she said everything received a copy of it.
Was that perhaps
The original, but that's not, yeah.
Oh, yeah, right.
We got to change it down or whatever, else. You may want to check again. Well, that's stuff.
Yeah. Oh, S9, yeah, I think the calendar has shot out. Use this document that you probably saw this morning instead of something else. Thank you.
Yes. I got it pretty clear. 2 paragraphs.
Well, I'll get one for each. So I'll run up and double check that.
You call them.
I can, yes. Senator Norris,
Yes.
Senator Vihopsky, Senator Bruce,
Yes.
Senator Meadows, yes, Senator Sheen.
Yes,
5-0.
amazing one. We've got about 12 minutes until Ben gets here, so we can go off like this.